The NRA wants changes to DOJ's rights restoration plan, and Buffalo mass shooting victims get a green light in a liability lawsuit. That and more on the news update.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the news update. Jake Fogelman, contributing writer at the Reload, is out once again this week. He's on his honeymoon, so I'm going to fill in for his hosting duties here. I'm the founder of the Reload, Stephen Gutowski, and with me again this week is our reporter, our National Journalism Center intern, Ben Owens. Welcome back to the show, Ben. Thank you for doing this again, filling in for Jake.
Hey, thanks for having me on.
Yeah, absolutely. We'll jump right into it this week, and I want you to describe for us the first story we've got. It deals with the NRA and this new DOJ rights restoration proposal, right?
Yeah, so last week, I believe it was, we talked about DOJ's new rights restoration revival. The program's been dead for something like 30 years now, and now the DOJ is bringing it back. And the NRA has a few things they want the DOJ to change with their new plan for rights restoration. So currently, federal law bars anyone who's convicted of a felony from possessing firearms. And under federal law 922G, they restrict 13 different categories of individuals. And one of the things that the NRA wants to fix in the rights restoration plan is to broaden who is not presumptively denied, because the DOJ is denying a lot of groups that are not necessarily violent. So like one of the things they wrote in their article was, quote, while the NRA agrees that an established propensity for violent conduct should count against granting the relief, we also think the offenses the rulemaking considers closely associates with dangerousness are overly broad. They include, for example, a long list of non-violent possessory firearm offenses under the GCA, or even broader state analogs, property crimes, controlled substance offenses, misdemeanors punishable by more than 2 years in prison, crimes in which the perpetrator and victim are not even physically in the same place, and even crimes against animals that have no human victims whatsoever. So that's kind of the first part of the plan that the NRA wants to change. They want some of the more non-violent crimes to not be presumptively denied for applicants.
Yeah, because this plan that DOJ has submitted has a number of categories where people can apply for rights restoration, but they'll be presumptively denied, or they'll have a period of 5 or 10 years where they'll have that presumptive denial status, right? And the rule talks about how these aren't supposed to be categorical, or the AG can make exceptions in certain cases. Extenuating circumstances can be considered one way or the other. Like if you committed a violent crime, but there's some reason why you can make a special case for having your gun rights restored, then the AG can do that under this rule. And also, if you committed a nonviolent crime, but a crime that's not part of the presumptive denial category, but the AG has some other reason to think that you're not eligible, you shouldn't be eligible for rights restoration, she can deny you. And the NRA here is just saying, basically, we think this is too broad as it's written. There's too much discretion. There's too much. There's too much of a presumption of denial across the board in a lot of these different categories. They want a much a much more open process for people looking to get their rights restored. And so they're asking their members to go and leave comments on the public rule during this rulemaking phase, and the public comment phase, and try to get some of these things changed. But there wasn't just those issues, right?
Yeah, so they had a few other things. One of them was essentially the red tape involved in the application process, because they mentioned you have to submit fingerprints, disclose your social, employment, medical, and criminal history. And some of those things the DOJ is already going to do. So you're So essentially, there's duplicate actions happening. You're presenting your criminal history, and the DOJ is already going to look in to find your criminal history as they do with background checks. So the NRA is essentially saying, why make it harder in this way?
Yeah, I mean, the DOJ or the NRA here is even kind of saying they're intentionally making it, more difficult than it needs to be, perhaps to discourage people from trying to apply for rights restoration. So that was kind of interesting. And same thing for the fee. They're like, there's no need for this fee. Although that's the fee is the only way that DOJ has to fund this this whole process right now. The Republican budget bill that deals with DOJ's budget and ATF's budget doesn't include any funding for this process, and they asked for, I think, $500,000 in their budget proposal for this, and they don't seem to have even gotten that. So the fee, if you read through the rule, is the only way they're funding this. But the NRA doesn't like that because they're saying, that it's not authorized by the statute. You're not supposed to have to pay a fee to get your rights restored, or at least that, that's their view. And the statute doesn't say, you can impose a fee on this rights restoration process. But additionally, they also are worried about, again, I guess goes back to discretion. They think there's too much discretion in a number of ways, not just in the presumptive denial status for a lot of these, people with convictions or other prohibited person statuses. They also think there's too much discretion in allowing the Attorney General to revoke any of these restorations, right?
Mm-hmm. Yeah, there's a lot of discretion for the Attorney General, and one of the things the NRA wants to happen, they're really calling on their members to send in comments to the DOJ so that strict rulemaking happens, where the Attorney General gets stripped of a lot of power so that future administrations can't change the rules to essentially gut the program.
Yeah, that was one of their top complaints was, okay, it's great that we have this rights restoration process. Like, the NRA is not entirely unhappy here, right? They like that the DOJ is taking this step, but they think it doesn't go far enough, is basically what they're saying. And they think it's too susceptible to manipulation by administrations down the line, because as we just outlined there, one of the issues is that DOJ and the Attorney General can just revoke any of these renewals in the future for any reason, and so they want some sort of safeguard there to, I guess, make it perhaps more of a process based on convictions or some future infraction committed by the person who had their rights restored, instead of just a discretionary system that leaves it up to the AG, because they're saying essentially, this system as it's proposed can be used to, great effect for what the NRA wants to see, a lot of rights restoration cases under a pro-gun administration, but then they're saying it's too susceptible to just complete reversal when, what they call an anti-gun administration comes into power again. So, it's interesting to see, I guess, this reaction where, it was, the language is not, obviously overly harsh here for the most part, but they do say some pretty severe stuff in terms of, the overall rulemaking. Like, here's one quote. It says, quote, "This rulemaking, however, would codify a very restrictive paradigm that would limit the discretion of future DOJ officials in taking a more holistic approach." So that's where they're complaining about these presumptive denials. And future anti-gun administrations could revoke, under the rules terms, relief granted by prior pro-gun administrations. So then they say there are a number of areas where we believe this initial proposal could be improved, and thoughtful comments can help steer the process in a positive direction. So they're certainly not satisfied by what DOJ has produced here. I think they don't want to necessarily alienate the administration, but it could lead to a situation where, similar to what happened with the NFA, the National Firearms, like silencer and short barrel rifle and shotgun tax cut that we saw in the reconciliation bill, where the outcome may be closer to what gun rights movement wants than where things started, but you still have kind of a rift at the end of it because the two sides aren't necessarily on the same page. So it'll be interesting to see what DOJ actually does in response to this effort from the NRA to get the bill, to get not the bill, the rule changed. If they adopt most of these changes, or if they try to stick with what they've already proposed. DOJ, as much as they might want input from political allies, they also, most federal agencies tend not to want to give up power over things. They don't want to give up discretion. That's a pretty rare thing to see. So it'll be interesting to watch how this plays out and see whether gun rights activists are happy with the ultimate outcome or not, or even if it is more pro-gun than the status quo was, so to speak.
Mm-hmm. I think that's right. Yeah, it'll be interesting to see where this goes.
Yeah, but we got another story here, right? We have you had a piece written on a new ruling out of one of these liability suits. This one stemming from the Buffalo mass shooting, and it was filed against it's actually sort of a gun accessory maker this time. Can you what exactly happened in that story?
Yeah, so in 2022 there was a racially motivated mass shooting where 10 people were killed, and so in California they have a rule where, because they have an assault weapons ban, one of the features that they don't want on your gun is a detachable magazine, which
you mean New York,
means that
right?
Oh yeah, sorry, New York. That's what I was going to say. Yes,
California also has a ban, but
California also has it. Yes, and one of the ways that this company called Mean Arms wanted to sell weapons that get around this is to make a magazine locker, right? So that goes into the spot where the button is to release your magazine, and it holds the magazine in place, and the only way to get it out is to essentially drill through it.
Yeah, so it's on an AR-15, right? It was it's like an accessory that you can install on a standard AR-15 that would accept detachable magazines. That makes it so that you can't easily remove the magazine anymore, right? That's the basic idea of what they sell, or what they used to sell. I think they stopped selling it.
Yes, and the shooter in this case removed the bolt, making his gun illegal in New York, of course. And so the company that made the lock is now being sued. And the Protection of Lawful Commerce and Arms Act that Congress passed earlier this century protects firearms. Yeah, I think so. It protects people in the industry of firearms from liability if their guns are used in ways they're not supposed to be used, such as in this case, except for a few exceptions. And one of the ways that you meet an exception is if the firearms manufacturer violated a statute, and if that violation is the proximate cause of the injuries in the case, right? And so in this case, the plaintiffs, which are the families of the victims of the shooting, are suing the company, and their way around this exception, or their way to get the exception under the PLCAA, is to say that they improperly marketed their product by claiming it was a permanent way to make your gun compliant with assault weapons bans such as that in New York. And their argument is this is not true because you can remove the item, which is what the shooter did. And for the sake of the motion to dismiss, the courts affirmed that, we will accept this for now, at least as an argument. Maybe they'll officially confirm it later on. But the lawsuit is going to continue, essentially.
Right. It's not a merits ruling. It hasn't reached the point where they have to clear that higher bar of evidence. It's a motion to dismiss, which they just have to kind of the judge has to determine essentially that the plaintiffs have a plausible case, more or less. And so it's a lower bar to clear, but still one that often these kinds of liability suits against gun companies fails to clear, because the protection of lawful commerce in arms, as you mentioned, gives liability shield to gun companies for the criminal acts of third parties that they weren't involved in directly. But yeah, the interesting thing here is this company that made this, they call it a magazine lock, but it's kind of it's a way of converting an AR-15 that accepts the detachable magazines into one that has an internal magazine effectively, which they advertised as making it compliant with assault weapons bans in places like New York. I don't think they specifically said New York in their advertising necessarily, but they said it would make them compliant with assault weapons bans generally. And so the big factor here seemed to be that on their packaging for this device, in addition to showing you how to install it or giving you instructions on how to install it, they also gave you instructions on how to remove it. And they made a video, I guess, that they published on their website doing the same thing, showing you how to remove this device. And those instructions are very similar to what the shooter did. I don't know that there's any evidence that's been presented in this case that shows the shooter actually saw these instructions from the company itself. This shooter, racist guy, killed 10 black people at a grocery store in Buffalo. He published a manifesto like a lot of these terrible losers do. And in addition to a bunch of rambling nonsense that you find in a lot of these types of manifestos, he described his, buying the gun and then removing this device, this magazine lock device, and the way he did it was similar to the way that they sort of advertised, or I don't even know if you'd call it advertising, the instructions that the company itself had put out. And so that was a big part of this case, was that this company advertised this thing as permanent, magazine lock that would convert your AR that could accept detachable magazines into one that has a permanent internal magazine. And then at the same time, they also would tell you how you can remove the device. Now, obviously removing the device is not illegal everywhere. If you had one of these, New York compliant rifles and you moved to Pennsylvania, you might want to know how to remove this lock and restore the functionality of the gun. But I guess the judges in this case kind of determined that the argument, at least, that these guys were, selling a device that isn't really permanent because they give you the directions on how to remove it, means that the device didn't really make the gun compliant with New York law. That was sort of the conclusion that the judges seem to have drawn here. And I think it is interesting in that regard. Now, I would say one other factor that's interesting to me about this case, at least, is they called this removable, the device, right? And again, as I mentioned, they did have instructions on how to remove it, so it is removable in a sense, but you have to drill it out to remove it. It's not like some of these other devices where you just have to unscrew it, or you have to use the tip of a bullet, your classic bullet button design. This one, it installs, and when you screw it on, the head of the screw breaks off as part of the installation process. And so the only way to get it out is basically to drill it out with an extractor drill bit, which is what they put in their instructions. But I don't know, that at a certain point, like, what's permanent and what's not permanent, I guess, becomes a legitimate question in a case like this. Like, their instructions for removing the device were basically just to destroy it.
Mm-hmm. Yeah, and the company stopped selling the device. So
it does
maybe
appear
they
that
are.
they've stopped selling it.
It appears they've stopped selling it, yes. And one thing that we need to look out for.
Go ahead and say.
Whenever they move on to the merits of this case, is going to be meeting proximate cause. right? So in the legal world, proximate cause means essentially that the actions of the person who caused the injuries, the shooter in this case, what were those actions reasonably foreseeable as a result of the false marketing, essentially, of the product? That's what we're going to have to look out for in this case. Or was it an intervening cause, which is where essentially the person who committed the harm has done something so extreme that it is outside the bounds of reasonable foreseeability, where all the liability shifts onto them, and then the original manufacturer is no longer liable.
Yeah, so this will be I think one to watch closely, especially because it's now cleared this bar of initial dismissal, which is where a lot of these kind of liability suits fail. And I do think that the big factor at play here was this company's publishing of instructions for how to remove their device that they also claimed was permanent. But again, it goes back to like what is permanent. I mean, this is where you get into a lot of the gray areas of these assault weapon ban laws, because is it really not permanent just because you can destroy the law? You can drill it out with a drill bit. I don't know. I mean, that's an interesting case for sure here, but important one because again, it made it past this early dismissal stage where a lot of these end up failing. But so we will certainly keep our eye on it. But we have one other story from us this week, right? I think deals with another northeastern state, New Jersey, right? There's the silencer ban there and the challenge to it. Can you give us a little background on what's going on with that one?
Yeah, so New Jersey has a silencer ban, and a few months ago, the Fifth Circuit ruled against silencer protections in a case called U.S. versus Peterson. We talked a little bit about this last week, but we've finally written an analysis piece to understand the arguments that are being created from the plaintiffs in this new case against the New Jersey government, where essentially the DOJ, after they got the ruling that they wanted in the Fifth Circuit case, the DOJ submitted a brief saying that they changed their mind on their position on the issue of suppressors, where suppressors are not necessarily, they framed the legal question around if they are arms or not in the original case. And the DOJ said they're not arms, and the court sided with them. But instead, they want to change the framework to say they're still protected under the Second Amendment umbrella, but some regulations on suppressors are okay, such as the NFA, and some of them are not, such as outright bans. So the plaintiffs in this case are trying to say that because of this new DOJ position, the outright ban is unconstitutional.
Right. We talked about this with Gabe Mailer on the interview podcast a couple of weeks back about that Fifth Circuit case, which is an interesting one, right? DOJ changed its mind after the administration's change. They came back and said, you got the right result in this case, which is that the National Firearms Act is constitutional under the Second Amendment, but you got there the wrong way, because silencers, while they're not arms necessarily, they're not protected arms, they are, essentially protected accessories. And so they enjoy some level of Second Amendment protection, but it's kind of a degraded lower level of protection that the NFA's tax and registration scheme doesn't conflict with, but these outright bans on possession, like New Jersey has, do conflict with it. And so the gun rights groups that filed this case, and it's another one of these coalition cases we're seeing more of, where the NRA is joining with a lot of other groups. You're seeing like a lot of coalition cases lately from the gun rights groups, although the overall number of cases seems to be decreasing a bit, at least according to the Trace's count of it. I think one trend you're seeing is more and more of these big coalition cases where they all get together and file one lawsuit. Because this case has like 6 groups, including the NRA and the American Suppressor Association and the local gun rights group in New Jersey. But anyway, they kind of jumped right on this one. I mean, it seems clear that they had already planned to file this suit before the Fifth Circuit filing happened. And their main contention is that silencers are arms and that they're in common use because there's a lot of them. and so they're protected, full fat protection from the Second Amendment. But they also acknowledge, and they use this federal filing to say, hey, even the federal government agrees with us now that this law is unconstitutional. It's New Jersey ban. So we'll see how much impact that has in court. I mean, obviously, a DOJ filing in a different federal district court in a case where they haven't, the court there hasn't necessarily agreed with them yet and may not agree with them. Overall, that was kind of, I think, Gabe Mailer's conclusion that it's not necessarily likely that the Fifth Circuit panel, even though they rescinded their initial ruling, is going to come back and change their mind about this question. We'll see. It's not impossible that could happen, but hasn't happened yet. But
yeah, we'll see. We only got a sentence from the
DOJ
court
filing there. Yeah, like they haven't explained anything yet, and just a filing is not as persuasive as even a ruling from a separate district court. And a ruling from a separate district court isn't binding, in the Second Circuit, I guess New Jersey is in. And the Fifth Circuit and Second Circuit are pretty far apart politically, as far as their leans go. So we'll see how successful this is at persuading whatever judge gets this case. But it is, it's interesting to see this what we predicted would happen is happening like really quickly here. So that was an interesting thing. That was what this DOJ, because you might ask, like, what's the point of this DOJ filing if they didn't disagree with the outcome of the case and they're still saying that the National Firearms Act is constitutional, even under this construction that they have for silencers enjoying some level of Second Amendment protection. Why even change positions if the outcome is not going to matter? And this is why, right? Because they're saying, well, this federal law is not impacted, but some of these state laws would be. And you're seeing the gun rights groups jumped on that right away. But we've got some links as well from outside the reload, just to go over briefly here. The first one up, I think, is some of the Sig Sauer news. There's a couple of links that we have on this, and there's also going to have a story later today. And we're going to have John Correa of Active Self-Protection on the podcast to talk about this whole situation, because he has barred the use of P320s in his classes. And so it'll be interesting to see his perspective on this whole thing as well. But speaking of barring guns from classes, SIG actually filed a lawsuit over one institution's decision to do exactly that, right?
Yeah. SIG has filed a lawsuit against Washington State Police training facility, essentially is what it is, where a lot of the counties in Washington don't have their own training facilities, so they bring in people from police departments from around the state to train at this one shooting range. And some of those departments do use the SIG P320 as their main firearm. Like, that's what the officers carry, so that's what they would practice with. And that organization, the training facility, has banned it from use in their facility. They won't let you shoot a P320 out of safety concerns. And this was a decision made by the president of that commission. And one of the things, so SIG has sued them over this.
Which is a government commission as well.
Mm-hmm. Yeah. And SIG has sued them, saying that this was not passed through proper rulemaking, and it's just based on prejudice against the company. So that's their take on it. We'll have to see where it goes. But they are heavily relying on the safety of the actual weapon in their argument, which will be an interesting thing for the court to analyze.
Right.
What are your thoughts?
This is from the New Hampshire Union Leader, is where this piece comes from, or the story comes from. Although there are a number of stories on this from local groups, but here's a quote from the director of this training facility, Monica Alexander. She said, quote, "My position has to be safety, because we know so much now that if I make a different decision, I don't feel like I'm being responsible." But SIG, in its lawsuit, said that the ban is, quote, unnecessary, unprecedented, not well grounded in fact or law, and harmful to Sig Sauer. By banning the P320 for new law enforcement recruits, the WSCJTC, which is the name of the training program or training facility, is putting these men and women at a disadvantage when they enter the field and will be assigned to the P320. The action also imposes negative financial impacts on all those law enforcement agencies that utilize the P320 and Sig Sauer. It further inappropriately and unjustifiably inflicts reputational and economic harms on Sig Sauer. Right. So they're basically saying this decision was made without evidence that the gun itself is unsafe, and therefore that harms both the Washington police departments that employ the gun because they can't go and train with their service weapon at this state training facility, and also hurts SIG because it hurts their reputation by making people think that their gun is dangerous. Now, obviously, there's a lot going on right now that's making people think that Sig Sauer's P320 design and the M18 design, which are the same essential design, are unsafe. But this is one example of the company pushing back against that. They've released a whole statement additionally saying, standing by the safety of the 320. And they've pushed back on some of these other reports, like there was a memo that came out or was reported on by a couple of outlets, including Breitbart was one of them, and then I think there was a sister publication of Task and Purpose also had the same report that a memo went out from ICE barring the use of the 320 or M18 as a sidearm for agents there. But the SIG this week put out a statement saying that ICE has extended their contract with the P320. So it's not exactly clear what's going on with the ICE. We've reached out to them a number of times now and gotten no response. So we have on record statement from SIG claiming that ICE has extended their contract. And then we have this leaked memo, which ICE has not confirmed the authenticity of yet, but there's a couple outlets claiming it's authentic. And then additionally, we know that there's the pause over that Warren Air Force Base incident where someone was killed, apparently in a discharge related to the M18, which again, the M18 and the P320 are the same internal design. They're basically the same design overall. And so we know the Air Force's Global Strike Command has paused the deployment of the M18 while they investigate this fatal incident. But we have another report, right, from Task and Purpose that says besides that pause, the M18 is still in use across the military. The Army, Marines, and Air Force and Navy are still using the M18 in regular service. So I don't know. The whole SIG situation is continuing to ramp up. I guess the big thing is to wait for what happens with that investigation in the Air Force. But right now SIG is certainly pushing back hard. But they've been doing that for a while. It's sort of infamously released a statement that basically told everybody to stop talking about it, and that the accusations of the SIG P320 safety issues were all lies, basically. So that didn't work when they did that back in March. That only invited more blowback. So we'll see how they navigate this period. Right now, they're still, of course, standing by the safety of the 320 design, and they're kind of going a bit on the offensive here with this lawsuit in Washington. But I don't know. It's a pretty wild situation. We will discuss it further, of course, with John Correa from Active Self Protection and get his thoughts on why he decided it. Why he thinks the gun is not safe enough to use in his training courses anymore. This Washington police academy is not the only place that's barred the use of the P320 in their classes after this rash of accusations and viral videos of the gun going off on its own. But there's a lot more, I think, to discuss with him. And so we can talk a little bit more about the story out of California, right? We have a story from, was it Cal Matters, on some new some legislation that has interesting implications that appears to be on its way to passing.
Yeah, it looks like they have a Glock ban on the table, right?
Why don't you give us a rundown of that? Yeah. Can you just describe a little bit about what the bill does?
Yeah, so the piece from California talks about how California is looking to be banning Glocks, such as the one that Kamala Harris actually owns, who is the senator from California, or was a senator from California. The bill aims to prohibit gun shops from selling new Glock brand handguns and various off-brand imitators, because the guns can become fully automatic if a criminal converts the weapon using a Glock switch. Yeah.
Right. Yeah, and so they want to ban the most popular kind of pistol, the most popular pistol brand in America, the Glock, because they claim it's more susceptible to these sorts of conversions to fully automatic than other firearms are. That's a fairly dubious claim, I think. Any semi-automatic, if you defeat the trigger reset sear, it could be converted to fire automatically. I guess the claim here, and you've seen this before, but there's a lawsuit out of Chicago against Glock for the same claimed defect, which is that it's easier to convert Glocks to do this than other handguns. Obviously, that's a controversial claim. There's still, a lot of people would say that's not, or a lot of gun rights advocates argue that that's not true, and that these sorts of bans would have huge unintended consequences, in addition to banning extremely popular firearms that are owned even by the standard bearer of the Democratic Party, right? Kamala Harris was very adamant about her gun ownership, and specifically her ownership of a Glock during the presidential campaign. And in fact, the governor of California, Gavin Newsom, was just profusely praising a podcaster, a right-wing podcaster, who gave him a Sig Sauer, sort of ironically. I believe it was 6 Hour, if I'm remembering correctly. I think it was an X Macro, 365X Macro. But either way, it was a semi-automatic handgun, which in theory would have the similar susceptibility as Glocks to this sort of illegal modification. And so, I don't know. It'll be interesting to see if, I don't think Newsom has spoken out at all against this. It passed the House with total support from the Democratic Party. The only opposition was from California Republicans. And at least according to Cal Matters, it's on pace to do that in the Senate next month, which means it may end up on Newsom's desk here soon. And, this Newsom's whole idea of being committed, being open to gun ownership and only wanting certain kinds of restrictions. I think how he goes with this law and some of the other things that have been proposed, like the micro-stamping requirement that we discussed, I think, last week on the show, will, I think, say a lot more about any sort of potential political conversion there on guns than his comments on that podcast did. But we will certainly keep an eye on this. California seems to be pushing back towards the more restrictive end of they're still trying to put more and more restrictions on, or bring back restrictions that have been struck down, even like the microstamping requirements. And so, it doesn't seem like there's any noticeable change in trajectory here at least from California Democrats. And if anything, they're continuing to push the boundaries of what's allowable under the Second Amendment. So we will continue to follow these stories, of course, at the Reload. Ben, you'll be here for another month or so, right? Or at least another couple of weeks.
Yep.
Until you're heading back to school after that, and maybe you'll have time to write some stories for us after you're back at school. But in the meantime, we're going to put you to work for sure on writing stories, doing background research for us here at the Reload. We've been really happy with what you've been able to do for us so far, and looking forward to the next couple of weeks here of having you on. Jake should be back, I think, next week as well. So he'll take back over the hosting duties of the show here. But yeah, that's
thank you for
that's all we've got for this week. Yeah, no, I think it's been fun to mix it up a little bit. Hopefully have you worked into the show a little bit more this time. I talked for most of the show last time, so it's good to get you eased into it more here. I think it was good, and maybe we'll have you on with Jake as well. I don't know, we'll see. But that's all we've got for you guys this week. We will see you again real soon.
Oh, the devil